Commissioners, you now have the ability to start your video and unmute yourselves.
Well, good morning, everyone. It's a pleasure again to see you all. This is Thursday, May 11th, 2023. This is part 4, our hearing on the California Environmental Quality Act. My name is Pedro Nava. I'm chair of the Little Hoover Commission, and thank you all for joining us today. I want to introduce the other commissioners who are with us. We have Vice Chair Sean Varner, always resplendent in his suit and tie. I fortunately have one black shirt that I like to wear for meetings. We have Commissioner Dion Aroner. David Byer may be joining us. We'll find out soon enough. Anthony Canella. I understand Bill Emerson may be a little late. Gil Garcetti is with us. Jose Atilio Hernandez and Yana Sidley. We also, I saw earlier, had somebody from the office of one of our legislative members, Senator Scott Wilk. We also have commission staff, Executive Director Ethan Rarick, Deputy Executive Director Tamar Foster, Analyst Ashley Hurley, Allie Powell and Shara McAllister, along with project managers Crystal Beckham and Tristan Stein. Let's do a little bit of housekeeping before we turn to the subject at hand. Commissioners, your audio and video will be turned on throughout the duration of the meeting. You may mute yourself if you wish. Just remember, I think we've all sort of learned this the hard way from time to time. Unmute yourself if you want to make a comment or ask a question during the hearing. The video and audio of our hearing witnesses will be turned on when it is their opportunity to speak. Members of the public will be muted during the hearing. We will have a public comment session at the conclusion. Those who wish to make a comment will be unmuted during the public comment session. If you'd like to make a public comment, please use the raise hand feature in Zoom by clicking on the hand icon to join the public comment queue. There will be some of you who have joined us by phone. You may either dial *9 to raise your hand on Zoom, or you can send an email to littlehoover@lhc.ca.gov, letting us know you want to speak to the commission. You must provide the phone number from which you have joined us so that staff knows who to unmute. Staff will be monitoring raised hands and emails requesting comment through the duration of our hearing. As is usual at commission hearings, public comment is limited to 3 minutes per speaker. We are recording today's hearing, and after the hearing, staff will place a permanent link to the recording on our website and upload it to our YouTube channel. Now to the substance of today's hearing. And before I do that, let me express my appreciation to staff for what I think is an extraordinary piece of work as they went through all of the legislative attempts to make some changes to CEQA, as well as the additional work of discovering which states have legislation similar to CEQA and how those are implemented. We do benefit from extraordinary work by staff for the Little Hoover Commission. This is the 4th in a series of commission hearings examining the California Environmental Quality Act, or CEQA. Since its creation in 1970, CEQA has been California's premier piece of environmental legislation. It has also, however, long been at the center of debate and controversy. Our first 3 hearings provided many different perspectives about CEQA. The first hearing, we listened to academic, policy, and legal experts regarding CEQA's impact, including both critics and defenders of the law. At the second hearing, we heard from CEQA practitioners. At the third hearing, we received different perspectives regarding CEQA from local governments. For this hearing, we invited representatives of organized labor to discuss the connection between labor standards and efforts at CEQA reform. Danny Curtin of the California Conference of Carpenters will testify, and we appreciate his participation and perspective. For those of you that are wondering, we did invite testimony from two other labor organizations, the State Building and Construction Trades Council of California and the Service Employees International Union California State Council. But SEIU declined and the building trades didn't respond. After Mr. Curtin's testimony, the commissioners will discuss what other kinds of witnesses they'd like to hear from at a future hearing, and then we'll have time for public comment. We anticipate holding one final hearing for CEQA on June 22nd in Sacramento. I want to thank Commissioners Sidley and Aaroner for serving on the subcommittee for this study and for their leadership on this crucial topic. This hearing was organized by Project Manager Tristan Stein. And now I'd like to ask Tristan to introduce the first witness.
Thank you, Chair Nava. Our witness today is Danny Curtin, Director of the California Conference of Carpenters. Mr. Curtin has served as Director for the California Conference of Carpenters since 2001, and he previously held the same position from 1992 to 1999. From 1999 to 2001, Mr. Curtin served as Chief Deputy Director for the Department of Industrial Relations. Mr. Curtin's experience in the California labor movement began in 1973 when he started as a union organizer and worked for the California Labor Federation. Mr. Curtin is also currently a member of the California Water Commission and serves on the California State Compensation Insurance Fund. In addition, he formerly served as chair of the Industrial Welfare Commission and is a member of the California High-Speed Rail Authority Board of Directors. Mr. Curtin, you may please begin your testimony now.
Mute. Let me start video. Okay, thank you for inviting me. I appreciate it. There's nothing I appreciate more than these cozy little conversations where I can't see anybody and so on and so forth, but we're getting used to that. Thank you, Dion Aaroner, for the phone call, and Tristan for helping me sort through all of this. Not so much a presentation. Tristan sent me a few questions to address, and then hopefully open it up to questions for the commission to ask me. I can't see anybody, so forgive me for not focusing. There really is a very convoluted conversation going on around housing, and not so much CEQA, but CEQA as a part of the enhanced entitlements associated with the housing projects that we've been talking about. So Tristan sent me a few questions to get the ball rolling that I should address opening up. The first was explain the California Conference why we believe that fast track development projects, including CEQA exemptions, should include requirements relating to labor standards. This is a more fundamental question about government and the idea of public works versus private works. And as you know, the 1930s, the whole concept of public construction got attached to higher wages and standards through the New Deal. And the premise here is that when government puts its thumb on the scale of private development, it actually is a benefit to those who are doing the developing. But it is also part of a public policy. They wouldn't do it otherwise. They'd let the private sector build whatever the private sector wishes to build. But when the government wants the private sector to build, you name it, roads, bridges, etc., they are actually the owners of the project. It's historically that set standards around those projects. Some of you may remember, I'm looking at the list here, maybe Senator Cannella, maybe not, maybe Senator Emerson if he's here. Around 2001, I believe, we passed the Bill 975 by Senator Alarcon, which sort of described government's intervention in the marketplace a little bit more expansively, so that anything that really gives the developers a financial benefit. No longer just is the government paying for the project. It could be a part payer, but it could be tax breaks, certain tax breaks. It could be the use of land. Anything that actually ends up being a financial benefit to the developer sort of now puts the government in the position of an owner of the project and establishes standards. So along with the standard of why the government intervened in that construction project, in this case, housing, we all know about the housing crisis. There are other public policies that can be benefited by the government intervening in this area. And basically, the one that New Deal basically started was the workforce needs in the housing industry. So we're really asking the housing industry, private sector as well as just flat out public sector, to really get going on housing, but not to abandon the workforce, which is really one of the lowest paid workforces in the state. It's one of the 4 basic industries that sees the most labor law violations, wage violations, tax violations, you name it. It's a very large construction industry. It's about a little over 300,000 workers, primarily non-union, like 90-something%. Only in the public works area to see much union penetration. And half of the industry is either low income, very low, or extremely low income. And the families of those workers, over 150,000 of them, receive over $3 billion, $3.4 to $3.5 billion a year in public benefits, public payments to those workers, either in tax, earned income tax credits, or actually food stamps, et cetera. So in effect, the government is subsidizing the worst contractors in the industry to the tune of $3.5 billion. So the developers that wish to use these projects now will have to pay a decent standard of wages, so that those benefits are off the table and the workers can be lifted up and actually be, in some cases, capable of buying or renting the housing they're building. So that's the first case. That's the public logic of why there should be other elements involved in this. There's another question here about what the labor standards should feature in bills that fast track developments. And the third would be the disagreement over the standards. And that's kind of where the rub here is, and what's our position versus some of the other positions that are out there. So let me just describe our standards that we developed, and this is the Carpenters. And I also want to explain to you why we developed these standards. But first of all, very simply, it's the payment of prevailing wages. And these are for privately developed projects that utilize the enhanced entitlement process, in this case, or in many cases, enhanced CEQA, CEQA issues, that actually becomes a monetary benefit. It doesn't take as long, it's less uncertainty for the project developer, and there really is a considerable amount of monetary benefit. So that's, again, the first logic. But the standards we're looking for are prevailing wages, which in California largely, not statutorily, but largely are union wages because of the process of determining what prevailing wages are. And start with that. Also, apprenticeship requirements, exactly as laid out in the public works format in public works statutes. Non-union contractor does not have an apprentice program, so they asked the unionized sector to provide apprentices, and this is identical to the public works law that exists. If the unionized sector does not provide them because they can't or don't want to, in some cases they don't, or they don't have any available, that contractor does not have to use apprentices, but cannot pay apprentice wages on the project. They have to pay journey person wages. That's
Mr. Curtin.
Yes.
Mr. Curtin. Hi, this is Pedro Nava. It's a pleasure to see you again. And I apologize for interrupting you, but what will happen, and it's fairly common, during the course of a witness testimony, a commissioner will have a question, and I watch the screen to see if a hand goes up, and our vice chair, thank you. Our vice chair has raised his hand. And so Mr. Varner, if you want to.
No problem.
Speak with Mr. Curtin.
Yes, thank you, Mr. Curtin.
I can see you now.
I understand you can't see us, but
I can see you now.
Okay, great. Let's appreciate you being here in your testimony. When you went through the items that you were listing, I wanted to ensure that one thing that you address that's critically important is CEQA is a statute that was implemented to protect the environment. And so I would like to know your position, the labor union's position, on how your involvement in requiring a project labor agreement addresses CEQA's impacts on the environment.
Okay, let me deal with that first, because it's really almost tangential in many ways. Most of the bills we're working with, we are not the main players when it comes to the land use portion of it, what the actual enhanced entitlements are. We're just really trying to protect the labor standards in the process. The legislators, and obviously we're not dealing with strip malls here, we're dealing with housing, which is a major crisis. So the entitlement that allows CEQA to be dealt with more quickly, and I don't know the details of that, and we did have this discussion with Dion and Tristan. I'm not an expert on CEQA. We have, just like anybody else, we believe the environment is mission critical here. But at this point in time, the legislature, the governor, believe that the housing crisis has a certain higher level where CEQA can be quickened. And there will be others, zoning rights and by right zoning and things of that nature. I'm not an expert in any of those. In fact, I'm not an expert in anything here, but I do know people who know things.
So Mr. Curtin, if I can just, I apologize to interrupting. I just want to make sure I understand what you're saying.
Don't worry.
So from a labor perspective and labor standards, rather than it being an impact on the environment, you want a seat at the table to discuss labor standards, not necessarily the impact on the environment.
Correct. We're not in the negotiation process to determine how much of CEQA standards need to be removed or expedited, or which particular zoning issue is. That's being worked out in other areas, in the housing committees, et cetera, et cetera. But for those entitlements, for those enhanced entitlements, which are really, forget the impact on the environment, are financial incentives to some degree. For that trade-off, we also believe that there should be an improved labor standard for a workforce that is really, in many cases, a crime scene and the lowest paid in the construction industry.
Isn't that a separate discussion than under CEQA, since CEQA is very specific with regard to impacts on the environment? Isn't the labor discussion something separate and apart and should be divorced from CEQA?
Well, you could say that, and yes, it is a separate conversation and could be divorced from CEQA. But if CEQA enhancement is part of the benefit that's being given to develop housing because of the housing crisis, that's a issue being dealt with through the legislative process. And a portion of that legislative process is the workforce standards that are going to be utilized in the housing development. And you're absolutely correct. It's a standalone conversation on the CEQA side.
Okay, I think we could probably talk about that for quite a bit of time, but I see my colleague Hernandez is looking to speak as well.
Yeah, thank you. I have another commissioner who would like to talk to you, Commissioner Hernandez.
But did that sort of clarify a little bit? I'm not sure.
Yeah.
No, I think you did make it perfectly clear as the way that you utilize the CEQA statute to get a seat at the table.
That's
Mr. Curtin, how are you doing?
pretty good.
For reminding me when I worked for Senator Alarcon, I should pay more attention to all his bills, not just the bills I was carrying. But
it was a big bill.
Yeah, no, I'm looking it up right now. Yeah, I was doing more. He had the Ending Poverty in California Select Committee, so we're a little busy with that as well. Two quick questions that's kind of related. I mean, so you were referring in terms of how you pay particular attention to kind of the enhancements or kind of whether it's a one-off or an exemption, particularly when we're doing affordable housing and so forth. This commission has had a conversation in terms of, instead of having one-offs, what if we create CEQA that is more, it's easier to understand, that you actually know kind of what the standard process is. Would that be an issue if there were, instead of getting these special deals, that if there was more of a standard way of approaching CEQA? Or do you feel like that would take away your ability to negotiate in special deals?
Whether you go after a standalone solution would be something that I'm not really going to be a part of to some degree, unless there's something that affects the labor side. But I do know the whole debate over CEQA over the years, and the utilization of CEQA and what might be the misutilization of CEQA definitely should be addressed. And I honestly believe that if it's a fair approach, we will have other, once the government steps in, if you decide that the CEQA thing is going to be expedited and the government steps into a project in a different way, allowing for some savings to a developer, that's what triggers the involvement for us to say, look, you're giving the developer a break. don't let them take their profits out on the backs of the workers. We should have in standards. So what you're saying is entirely separate, just like Commissioner Varner. It's a very healthy conversation. And if you do come up with a formula that does expedite CEQA, that will not really impact us in the way you're thinking.
So that was the second question, the timeliness of this. I think that, I mean, what we hear is that sometimes just the duration of the CEQA process is an issue. But what I heard is that's not where you're coming from in terms of.
Well, only in the sense that developers feel like it costs them a lot of money and then the project could go south and so on and so forth. And we're talking about housing here. Remember, this is a housing crisis. It's not just every construction job. It's the housing crisis. And the housing workforce is purely extremely exploited. So this is an opportunity to do a second very important social benefit, which is to raise a workforce up to basically a blue collar middle class workforce.
Perfect. Thank you.
Thank you. Also, Commissioner Sidley has her hand up.
Thank you. Thank you, Mr. Curtin, for your testimony. I'm going to try to, I think, rephrase what you're saying to see if I'm understanding what you're saying. First, what I think I'm hearing you indicate is the uncertainty with CEQA impacts not just everybody in the state of California for housing, but specifically from your members and whether or not there's work available to build this housing. So work is delayed while people are going through the CEQA process. Is that a fair understanding of the position of the Carpenters, or no?
No, and I'll tell you what.
Okay.
The housing construction industry is like 93% non-union.
Okay.
The issue that we're dealing with is once there is an exemption of some kind, CEQA or zoning exemption, then there's a process of raising the standards for the developers that use that exemption. We're not arguing about the CEQA portion of that as much as you're giving, the government is putting their thumb on the scale to build housing, giving developers a break of some kind. Whatever they calculate the cost of CEQA, that's a whole different story. But since the government is now weighing in, we're arguing they should weigh in on the conditions of the workforce, like a public works job.
I see. Okay, so if there is a CEQA exemption, then government has been involved. So they're not necessarily putting in direct dollars, but indirect dollars. That's making it a public project, and therefore, whereas most public projects you would have a project labor agreement, prevailing wage, your position is that if there's going to be an exemption for housing or for whatever, government's taken an action, that's right. And then it's only fair and reasonable to give the benefit to not just the developers, but to those that are building the actual project. That's
correct. It's another public policy associated with a change in policy, which is affordable, makes it more affordable to developers. And if they want to do it, they have to pay the freight to the workforce. And if it pencils out, they'll do it. But it's not technically a public work, but yes, it's the same as if it were a public work.
Understood. Yeah. So a classification of a public work, however you do that, is sort of where you're going. Okay, so let me then ask you another question back to what I phrased, which you told me was incorrect. Do construction workers, well, you would only know your members, I suppose, but are construction workers suffering as a general matter by the delays in CEQA?
Our construction workforce is doing pretty well, largely, I think, because some of the federal money and state money, and there's lots of infrastructure. You got to remember, in the housing industry, last year was maybe 130,000 units housing built. We build less than 5% of that. Our workforce dominates the public works infrastructure kind of workforce and the more complex high-rise, more costly developments. So would I say CEQA is actually impacting us? Not precisely. In terms of the economy and in terms of general development, there would be an impact, but we're working at a pretty high rate. Our unemployment rate is pretty low. But we do most of our work because government is about 25% of the construction marketplace, and that's where our strength is. in terms of market penetration and the higher level construction projects that, you name it, energy factories or power plants, that are private. Yeah, that's where our work is. And the housing industry is largely, majorly non-union. So we believe we should be organizing those workers, but our contractors can't compete when they're getting minimum wage. We're getting paid under the table. So you raise the wage level, and this we can talk more about what the differences between us and the other crafts might be. By the way, but anyway, you raise the wage level to a prevailing wage, which our contractors pay our members. They will get there and compete because we believe we have a more productive, efficient, well-trained workforce, and we'll organize some of those workers to. That's the theory.
Understood. Okay, I appreciate you explaining that to me. I think I understand it more clearly. I see Commissioner Canella has his hand up, so I'm done. Thank you, sir. Much appreciated.
Yeah, Commissioner Cannell.
Yay, Danny, it's nice to see you. It's been a while. Hope you're doing well.
You too.
Hey, so in the staff report, and I work in home building, so I've seen this as well. It says that some attorneys have related that many developers, including developers of affordable housing, will decline to use any exemption that requires either a skilled and trained workforce standard or prevailing wage standard. According to these developers, both these requirements can make it impossible to get projects to pencil out. So what we have is there are these avenues to go down that may shorten CEQA, but per the staff report, it increases the cost, which makes it not usable. So how do you respond to that? How do we accomplish what you have worked for to get higher wages, but then still get an avenue where it can be used?
So if it doesn't pencil out, it won't get used. The history we have now is SB 35, which has a bifurcated sort of system where affordable housing is a prevailing wage standard and privately developed housing with a certain level of affordability, low, it's 10% low income or whatever. Nobody's building that through using SB 35, which is a CEQA exemption and a by right zoning exemption, because the skilled and trained workforce does not exist in that area. Basically, the skilled and trained workforce standards says if you are not a union member, and I'm paraphrasing, there's a lot more complexity to it, then you can't build. You're not eligible as a construction worker. When you say prevailing wages, any contractor who's willing to pay prevailing wages, union or non-union, can compete and can utilize that standard. And it's worked in the affordable standards. We've got somewhere around 15,000 units in 5 years, but nothing in the private sector, because the developers will not take the liability of trying to make sure that everybody on that workforce meets a very complex, skilled and trained standard. So what we're saying, and by the way, the standards that we're pushing, which depends on who you talk to, AB 2011 standards from last year's bill, the housing industry, nonprofit and profit developers support our measure. Not all the profit developers do, but the California Housing Consortium co-sponsored this bill, and they are profit and nonprofit as well. So that in the profit area, if it pencils out, if there's enough of a CEQA expedited break and a zoning break for a large enough project, then they can pay prevailing wages and still make money. That's when they're going to do it. And we're hearing from the California Housing Consortium, which you might want to check in with afterwards, and they are profit and nonprofit developers. They're supporting the bill because the other one basically stopped them dead in their tracks. They cannot meet the skilled and trained standard. And if there's a violation, they're liable. The general contractors are liable if a subcontractor doesn't meet the standard, and the penalties are quite substantial. But they can meet the prevailing wage standard. They understand it. It's public works. Some of those people you're talking about as developers are familiar with public works, prevailing wages. They know how to do it. So if they see it pencils out, they're going for it. That's me. Some of our contractors, by the way, will get into the housing industry as well because the wages have been raised to something that they have to pay.
Yeah, it seems like in the affordable housing sector that my company personally works in, usually there's a lot of government money that's added to it, which triggers the prevailing wage. So it makes it work. So I still wonder if it was prevailing wage for single family residential that where there's no government money. I just
Not
wonder how that would make
Right.
how could the houses still be affordable or in a range? So I'm just
Well,
thinking out loud.
Look, I'll just give you 2 seconds more on this because it's important. Single family housing, if there's no intervention and they do not utilize the expedited CEQA and by right, provisions, there is no intervention. They pay whatever they want. Okay, but now that the housing costs are somewhere in the $800,000 range for single family homes and above, the cost of the wages is less of a deterrent. And if the CEQA, expedited CEQA and the by right zoning and within the sort of the RENA plan, it's height limits and stuff, the people you're talking about, these developers are pretty smart. They're going to look through that. And if they get enough on one side, they can afford to pay it on this side. Those homes are moving. That's the theory. But the real issue for housing is not the single family units. That's a housing construction industry issue. But for the government and for the state, really the multifamily, 3, 4, 5-story multifamily projects are really at issue here. And, there's benefits in terms of more units available if you do density bonus issues and paying the prevailing wage does pencil out, at least according to the California Housing Consortium. They're the experts.
Thank you, Danny.
Yeah, thank you. You may, go ahead. Go ahead, Mr.
Keep going. Okay, so let me just tell the other 2 elements. One is if you're a housing project over 50 units, which is not terribly big, but it's also not small, you have to have a healthcare plan equivalent to the cost of the California covered California Platinum plan for a family of 4. And the most important factor from our point of view in many respects is the ability to enforce the law privately through the labor management cooperation committees, which are federally recognized. Right now, the odds of a contractor seeing a labor commissioner on the job is once every 300 years. The housing industry is a major crime scene in terms of violations of wage laws, no wage statements. It's really, really difficult. It's largely Latino immigrant workforce, and they are exploited, no doubt about it. We are really sort of chomping at the bit to get into the industry and start raising the standards. So those are the 4 elements of our plan. So how does that differ? Let me see what the last question, how's that position mandatory labor, and how does it differ? Well, the point that Senator Cannella made was prevailing wage standards sort of versus a skilled and trade standard. The skilled and trained standard is basically you have to have been a graduate of an apprentice program, which are almost exclusively union programs. You have to be in an apprentice program, or you have to prove that you've worked enough hours in the industry, the construction industry, in the craft you're working in, as if you did graduate from an apprentice program. And that is anywhere from 4,000 to 8,000 hours. There is virtually nobody in the housing industry now who's non-union who can actually prove, and I know this is not a demeaning statement in any way, keeping 5 years of payroll records doesn't even actually prove it. It just proves you were working somewhere, not what you were doing. So it has become a standard that is not reachable. And it's more of a barrier, okay? And it's sort of a protective process from the building trades. And I'm not knocking that either. It's worth a conversation, maybe not today. But the developers will not take the liability to prove that they have a skilled and trained workforce in an industry that is largely 90-something% non-union, because they cannot meet that standard. So they won't utilize these enhanced entitlements. They will not use them. They've made that clear. And so that you understand, and this is important, we didn't decide to do this. We were invited literally by the housing industry advocates about 3 years ago. Really, can you please come in and see if there's something we can work out? The leadership of both houses, particularly the speaker, basically said, we're not passing any more bills with skilled and trained because nobody's using it. The pro tem's office, the governor's office, you name it, we're all saying, is there a way to work this out? And we made a healthy effort. We thought we had an arrangement, but it fell apart. So we came back with these standards, which are completely inclusionary, both for the workforce and for the contractor base and the developer base. Yes, it costs them more money, but there's no penalties. If you use the skilled and trained standard and you violate that, penalties multiply drastically, and it goes up the chain to the general contractor, and in some cases, the developer who is supposed to develop the standards, which in and of itself is very complicated. That's the nature of the fight and the difference, and I should say fight. And we're in it right now with the language and the bills that are coming up now. SB 423 is the focal point for this conversation. That's pretty much what I was opening with. So if you want to know more about the differences, I can deal with it. I also want to caution you. I mean, those who in the legislature in the years past know I'm a pretty straight shooter. I'm not a salesman, except to the degree that I have a good product. And we believe our labor standards, and I don't mean we believe, these are the strongest labor standards in the country right now. If you include the skilled and trained standards, which are not being used, we feel those are a barrier. So prevailing wages, healthcare, self-enforcement, which is unheard of, and use of apprentices where available. That's basically the public works piece. But the self-enforcement is going to clean up a lot of jobs that are not getting cleaned up now because there's just no enforcement capabilities. When you look at garment, when you look at ag, the Labor Commissioner's office is completely overwhelmed. And we are one of the 4 industries that they consider rampant in terms of violations. That is the nature of the disagreement. And they're arguing, I would say, oh no, it'll work, just do it again. The evidence so far in 5 years of history, SB 423 is an extension of SB 35 from 5 years ago. It's going to sunset in 2 years. Has been no private sector development utilizing those particular enhancements, and somewhat substantial on the affordable side. Keep in mind that the affordable housing development is only a small portion of the housing needs. So the private sector is going to have to play a major role. And if there's going to be a government, putting its thumb on the scale, there has to be a standard that they can actually meet. And the developers and the housing advocates are all supporting, virtually all. There are none on the skilled and trained side that I'm aware of, but list after list. The cities are a little concerned about it because they're believing their zoning rights are going to be taken away. But I believe that conversation is almost, that horse is out of the barn to some degree. That the RENA standards are now starting to be, let's see who's making housing and who's not. So that's the nature of it. I could do more details if there was questions.
All right, thank you, Mr. Curtin. I'm looking at the commissioners. I do. Bill Emerson has raised his hand.
Hi, Danny. I
Pleasure.
don't have any specific question. I just want to say thank you very much for your time. It's good to see you again, my friend.
Appreciate it. Let me just go a little bit more into the long range questions here, concerns here that have been raised, not by the commission just yet, because I know you're focusing on CEQA, but this was wasn't still a housing crisis. The governor called for 2.5 million homes I think by 2030. We are barely keeping up with about 125,000. We are not breaking any records, let's face it. So it's still a major crisis. And I go back, we did not approach this as we're in it to compete with anybody in the trades, but the trades are not doing the housing work. Let me give you a statistic, which is a bit frightening. There's over 300,000 workers in the housing construction industry, somewhere around 330,000. Of course, it depends on the economy. There's about 300,000, maybe, actual union construction workers in the state, period. And considering that they're not in the housing industry, except about 5% on the public works side, the idea that we can handle that project by just simply saying you got to use union construction workers is a fantasy. And I'm being kind of gentle on that respect. But of the 300,000 union construction workers, there's probably 1 million construction workers in the state, maybe a little less. That sounds about right, because the government is about 25% of all construction, and that goes up or down 20, 25, 30, depending on the economic stimulus issues. So we are about 20, 25% of the workforce in the construction industry, and have been for quite some time. We used to be 35, 40%. That has been on the decline. In the 60s, which some of you may remember, I certainly do, the housing industry was far more unionized, but it just slipped away because our workforce went into the construction and the industrial sector and into the government sector. That is a massive low-wage workforce, which brings down everybody. even in the housing industry, even those who want to abide by the rules have a hard time because it's such a cutthroat industry. We're chomping at the bit. And by the way, our bill now is supported by the operating engineers and the laborers. That's more than half the construction industry workforce unionized. And now the cement masons and the plasterers have joined on. There's a different dynamic going on here. We'll see more as it goes forward. But the union movement here is beginning to recognize that maybe we ought to take a step back a little bit and work with prevailing wages. And again, self-enforcement, I can't tell you how powerful that can be to cleaning up work sites. So that's the nature of the fight. Is it a standard that was established not in housing, but actually in the oil refinery industry, which made a lot more sense because that industry is much more highly unionized, much more specialized, also a much more dangerous industry if it's poor construction work. And that was the premise, is why skilled and trained. I see, Dion, you may have been there for that particular language. We supported that. We still do. You need a safety issue, well-trained workforce there. But in the housing industry, all you're doing is keeping 300,000 non-union construction workers from building the housing that they're already building. And we cannot fill that need. So we are opening the door to anybody who wants to pay the freight, union, non-union contractors, and any union that wants to go out there and start competing with their own contractors or trying to recruit contractors from the industry. By the way, if you are going to build a union with a union wage, your first thought would be, well, I may as well get the advantage of a skilled trained workforce. I'm not saying that the workforce out there is not competent. Trust me, these are hardworking people. We see them as future members, by the way. We do not see them as competitors. And that's a major sort of philosophical difference. These are not people who don't know what they're doing. They're working hard. They're taking care of their families. In many cases, they're taking care of people back home. These are the kind of people who build America, but it's time to give them a fair shake here. I call it a New Deal. So the government is intervening. It's time to bring that to the workforce as well, but not in such a way that only union contractors can do it. And a lot of union contractors can't do it, by the way. Our general contractors are very reluctant to get involved in this because they will be liable for the violation of subcontractors. That's not a good deal. And the developers they see so much risk involved in it. That's why they're not building.
Commissioner Arner has her hand up.
Yeah, Danny, I just want to thank you for your honest testimony today in sharing with us the differences. I know it's not easy always to come forward and give clear explanations of what the differences are here. But I really appreciate it and want to thank you for it.
So my pleasure. I must tell you, we were supportive of skilled and trained in the oil refinery industry.
Mm-hmm.
We're still interested in coming up with a formula that works in the industrial sector, because from our perspective, the growth in America, the growth in California for construction workers is going to be in decarbonizing the atmosphere. Mm-hmm. The industrial work that'll be associated with that, never mind the need for the electric vehicle networks, transmission, and everybody having a electrical vehicle outlet is going to be enormous. I mean, we're seeing changes in the railroads and the buses. There's so much industrial work out there. And we need a skilled and trained workforce in that area. We're very supportive of it. But if we do it in such a way that the risk is transferred completely to the developer or the general contractor, it's not going to work. So we didn't join this fray because, we're looking forward to breaking ranks. We were very, very reluctant. And literally, as I said, we were asked repeatedly by housing developers, not so much the developers as more of the housing support network, to come in and see if we could find a formula, because it was a lockdown. We thought about it carefully. We did have a meeting with the president of the building trades. I say we, it was a very high level meeting. I was a fly on the wall. We thought we had an agreement. It didn't work out. So we then went ahead and came up with a standard that could work for the developers as well as for the workers. We ran it by the California Housing Consortium. We were told that they were the sort of the biggest single group that represented the whole industry on the developer side. They came back about 2 weeks later, somewhat to our surprise, and said, we can handle prevailing wages in healthcare, and you guys actually doing the enforcement. We've done the work, and those that pencil out, we'll do it, but we can't do it with the other one. So we're not only inclusionary to the workforce, because we're not throwing anybody out of work. we're inclusionary to the construction development community. And that just seems so logical. It's hard to believe we're still actually dug in the way we are. And we're not out. I mean, we're going to have another, those of you who are members, I see all of you are, most of you, or at least half of you are former members. You know how it gets towards deadline time in a probes or at the end of the session. A lot of hard decisions are going to get made, and some will ruffle feathers and so on and so forth. But you know what? That's the nature of the job. I caution everybody who I talk to and who's elected. You decided to run. Nobody recruited you to go through the hell they're going through. Actually, it's a great job, but sometimes it's really complicated and difficult. So we're at one of those times. But we got a housing crisis. It's not strip malls. It's housing. Housing is mission critical. And if you can't build housing, with prevailing wages, then maybe we got to find another thing. But we got to bring that workforce back into the middle class. And by the way, I say all the time, and I said an article around, I don't know if you read it, but we face two basic, one's an existential threat of climate change, but the wealth gap and the tremendous disappearance of a working middle class, I believe, is what's at the foundation of the political dilemma we're in. And until we build back a sort of a healthy blue collar middle class, we're going to be at each other's throats, especially in America, where the demographics are just so overwhelmingly diverse. It's amazing that we're not at each other's throats. But what brought America together was the land of opportunity. And if it's just a poverty workforce, that's going to get uglier and uglier. So I'm preaching now. So
Thank you, Mr. Curtin. I think we have exhausted that topic at this particular juncture. I want to thank you for taking the time to join us and to provide us with the additional information that will help us work through our recommendations. And thank you for being so generous with staff and with commissioners. Appreciate it.
My pleasure. And by the way, this is one of the third rails, so have fun. It's going to be an interesting proposal that you guys are putting out there, but it's timely and important. So, it's another balancing act. Thank you so much.
Thank you.
Okay.
Thank you.
Now let me turn to Ethan. If you may recall at our last meeting, we started to have a fairly vigorous discussion prompted by questions by commissioners who wanted to weigh in more on a deeper level with respect to the report. We don't have a draft yet. Normally, what we do is we'll bring a draft to a business meeting. There'll be discussion at the business meeting and usually adoption of the report with some minor edits. But it was certainly my sense and that of commissioners that this report had so many aspects to it that it wouldn't likely be resolved the same way we've done it in the past. And so that's why with everyone's agreement, we thought that we'd have a meeting where we could have more time for individual commissioners to express their sentiment about what it is that we've covered so far. So why do I get that basically right, Ethan?
I think that's exactly correct, Mr. Chairman. This portion of the meeting is really, as you say, in response to commissioner comments at the last meeting, in which commissioners expressed a desire to weigh in both with regard to the kinds of witnesses that they still wish to hear from, and then eventually potential recommendations. I think what would be probably most helpful, given that we have decided to use the June 22nd hearing date for the final CEQA hearing, what would probably be most helpful for this discussion is a focus on the kinds of potential witnesses that commissioners would like to hear from at that June 22nd hearing. We plan on, at that hearing, having an additional commission discussion once we've taken all the testimony of potential recommendations that commissioners might wish to see included in the report. So there will be time on June 22nd for commissioners to weigh in with regard to what they think the potential recommendations should be, and then we can take that back and work through those at the subcommittee and staff level. But for the purposes of this conversation, I think the benefit, which commissioners expressed a desire to talk about last time, would be to discuss the kinds of witnesses that commissioners would like to hear from on June 22nd. The one caution I would make is that I think it probably will work best if the full commission defers to the subcommittee and the staff with regard to individual people and who we actually end up having testify on the 22nd. That's largely just a logistical issue. All of you could decide to invite Bob Smith, and it turns out Bob Smith is on vacation in Greece in late June. And so we have to be able at the subcommittee and staff level to pivot to some analogous person. So I'm not sure that we can hammer out exact witnesses, but I do think that based on what the commission expressed at the last meeting, a discussion of the kinds of people you'd like to hear from at the June meeting would be helpful. And so
Okay.
I would defer back to you, Mr. Chairman.
All right. In order, the way I saw the hands go up, it was Sidley, Canella, and Hernandez.
I'm pulling my hand down for the time being. Thank
All
you.
right. All right. So Sidley is off the table. Let's go to Senator Canella.
Yes, thank you, Mr. Chairman. I wasn't at the last meeting, so I'm not exactly sure what was discussed, but as we've gone through these conversations since the first meeting, obviously CEQA encompasses a lot of things other than just housing, right? So housing, honestly, I'm getting a little PTSD from all this CEQA talk from when I was in the legislature, but it's there are other areas that I experienced where there's some challenges with CEQA, and it would be nice if we could figure out a way to expedite it. The first one is in wildfires. When we had a wildfire subcommittee when I was in the legislature, and we had folks talk about their inability to do timber harvesting because it took so long to go through CEQA for timber harvesting. And that was a real problem during the wildfires, whereas because of climate change, the separation of trees from power lines, 30 years ago, it made sense, but now with the winds and the speeds, you really need to go wider than that. But it would take 5 years to get through a timber harvesting plan, and it just didn't make any sense. So I think it'd be nice to hear about that component, because we're really not out of the woods when it comes to wildfire, no pun intended. The other area is public works projects, bridges, utilities. Some of them are exempt, a lot of them are not. And so if you have a bridge that's problematic, if you have to go through CEQA, that takes a long time and it puts the public at risk. So maybe you guys had those types of witnesses in the last meeting, but I think that's important because it does highlight some struggles with CEQA with areas other than housing. So
Terrific. Thank you. Commissioner Hernandez, and then I also have Garcetti, and then Sidley.
So I think similar, and I also had a question about June 22nd in terms of, it'd be great to have some kind of structure. CEQA is so vast, something for us to react to instead of just coming up with recommendations, just what should be in the report. But I do like what Commissioner Canella was saying in terms of, in the rollout, different phases, or kind of how do you digest this? You can't eat it all at once. And so maybe going deeper on some of the subsections, for example, not just public works, but there's a huge electrification issue. Be great to find out kind of what's happening there. I know that it was in the original memo I read. It was only 174 pages. Thank you, Ethan. But, and it's related to what I'm seeing in other states. I think at last commission, someone asked for what are other states doing. Right now, this electrification issue is happening in other states. So that goes back to the larger question of kind of a CEQA related either regulations or laws in other states and how they're being resolved. But again, just to kind of recap, some kind of structure to the 22nd in terms of kind of something for us to react to. And yes, going deeper on some of the other issues.
Yeah, thank you. I just, by way of, I found on page 11 of the material provided to us, the staff was able to pull a section called comparable laws. And so there is some discussion in that document as well. Commissioner Garcetti.
Thank you. This whole discussion we've seen is, at least for me, and I think for most of us, so incredibly complex that it almost begs the question, where do you start with some of this? We've been going over it. The meeting that I missed, I listened carefully to the testimony there. What was missing, and I feel it is still missing, and perhaps surprised me the most about this, was the role of the judiciary. Those judges who hear the cases or don't hear the cases. So I would love to have someone speak on behalf of the judiciary who could answer our questions about what their role is, how has it evolved? Are judges who are hearing the cases happy the way it's being handled now? Because it's a mixed bag, I feel. Who you can invite, I leave up to you, but don't forget to look at retired judges, like the Supreme Court, former Supreme Court judge. I don't know if she would be willing to come on, and I'm not sure, what judges would be willing to come on. But if we could get someone to speak at least on behalf of the judiciary's role in this, that would be, I think, particularly helpful.
Terrific. Thank you. Commissioner Sidley.
Thank you. And thank you to all the commissioners. I have a couple thoughts and then sort of a philosophical question. My first is to just a thought to Commissioner Cannella. When the Little Hoover Commission did a study on the health of the Sierra Nevadas, we did look at some cutting issues and some issues about CEQA holding up those plans. So I think in many ways that the Little Hoover Commission has material that we can pull from to address that. It was part of the, I also was the subcommittee chair on that. And there was testimony about how CEQA does delay it. And we did come out with some unique, I think, recommendations, but I do think there is material in that study that might address that particular issue. And then to Commissioner Garcetti, I think hearing from the judicial branches is also very important, but I do want to just clarify that there is, and I'm not exactly certain what was said at each one of the hearings, but I just want to clarify that there is currently CEQA training for justices. There are some specific jurisdictions that have CEQA judges. In the larger jurisdictions, the smaller jurisdictions, they don't necessarily have specific CEQA judges. I think that the training, I happen to know two of the trainers personally. I think the training is excellent. I think maybe insufficient for the complication of what this law is. And so I just want to make clear that nobody is disparaging what people are currently doing in terms of their skills. The issue, I think, is whether or not there should be CEQA courts specifically or more training. And if so, is there money for that or whatever? So I just wanted to share that because I've heard a little feedback about, are we saying that it's not good? And I think maybe not, it's good. It's just maybe not enough given how rapidly this law is changing and how much it's impacting our state. And then I guess what I'd like to put out and love to hear from the commission sort of philosophically, as you've heard through this testimony, and I've dealt with CEQA as a practitioner, and I know many of you have not, and so you're learning it, but there are exemptions. There are statutory exemptions, categorical exemptions, and I'm just wondering of thoughts about exemptions around specific needs that the state may have. Housing, public works, fire, things that you've all brought up. Is that something that you're interested in exploring more, or are you interested more in a generic type of tweaks to CEQA? That might be too difficult of a question, but I'm really, since we're having this discussion, I'd love to hear your thoughts.
Commissioner Hernandez.
I mean, quick reaction is that we shouldn't create policy based on the exemption. So I can't remember which commissioner it was that said, well, we have all these exemptions, why don't we create policy that works for everyone? I think that's kind of the approach I thought we were going at. But if that's not a reality, then maybe, yes, we should start kind of making clearer, easier, figuring out the process and setting up the 122 different exemptions that we're going to create.
I mean, it was me actually who said, can't we get a law that everybody can use? But I just want, and that was my philosophy, but I just wanted to throw that out there. So thanks.
Garcetti?
Yeah, I appreciate Commissioner Sidley's comments about the judiciary and the training they're getting, and that's important. She certainly, or you do, to have the advantage, one, of having talked to people who do the training, and two, having participated in this yourself. So you're much better informed than those of us who've never had that opportunity. But I'm still bothered by not fully understanding and appreciating what the role of the judicial officer should be. Is there consistency between Judge A in one jurisdiction and Judge B in another jurisdiction? Do we need that consistency? Should there be the consistency? But I think the most perplexing question of all for me is really somewhat unanswerable, and that's the politics involved here. I mean, my God. I mean, you have truly believers on both sides, and they're articulate and they're good, and they have persuasive reasons for their positions. It's a challenge to us, but I love we have that challenge. Here's an opportunity that maybe in dealing with it and learning about it, we can come up with something that will be meaningful at the end. So thank you.
Yep, thank you. With respect to our forest management report, one of the things that actually may be helpful is that if you remember in that report, the state lands represent somewhere in the neighborhood of only 3 or 4%. Isn't that right, Jana? 3 or 4% of all of the forest lands. You got 40, almost 50% is federal. And then a whole lot of the rest of it is private. So it is worth a discussion because you're right, we're not out of the issue of forest management. We also, as part of that conversation, could be, what are we doing about biomass? Somehow we've managed to forget about, what was it, 130 million dead trees throughout the forest.
Yeah.
They're still dead, and they're still on the ground, and they're still fuel, which contributes to, serious problems when you have the forest fires. Sean, you got anything? I don't know that we want to cycle away from this just yet, but as a vice chair, I thought I'd ask you.
Pedro,
Yeah.
my apologies. I'm having something delivered as for the meeting, so I stepped away. For a second. I just want to also for the commission to think about, CEQA is so challenging. And particularly for those of you who are not practitioners, those who are practitioners, it still boggles the mind. So I want to make sure that we do get a report out, because we can take on too much. And so the answer becomes, here's report 1, and we may do a deeper dive into another section. Personally, I'm open to that. I would hate to see that our report gets completely sucked into more and more studies, and we never get anything out, and we never make any progress. So I just put that out as a cautionary note for all of us, me included, because I mean, I can get really in the weeds, and I'm trying not to. I am trying to be at a level much higher in order to actually put something out that is helpful to the citizens of the state of California. And so, but if that means then we do a deeper dive at certain particular areas, as a personal matter, I'm more than willing to do that work and participate in that. And I just wanted to share that thought.
Yeah, thanks. Yeah, I don't think that I had heard from anybody that this was something that we weren't going to put some sort of a candle on. I do think that we have all been sensitive to what Commissioner Beyer would call boiling the ocean. And this CEQA issue has the potential to lead us, down that, I'm mixing so many metaphors, down that rabbit hole. So I better shut up. Commissioner Hernandez, and then Commissioner Aaroner.
I think that was what I was alluding to in terms of June 22nd, in terms of for us, something to react to, because we can just, go forever. In my head, I'm already writing down kind of phase 1, phase 2, phase 3, or immediate, short-term, long-term. But it would be great to kind of, since you have a deep understanding, kind of maybe get us thinking in that way. But yes, we should have something that we can implement sooner than later.
Can I just say, Mr. Chairman, we will, in response to Commissioner Hernandez's concern, we will definitely bring some structure to the discussion on June 22nd in the form of a memo or document that we work out at the staff level with the subcommittee, and that will give the full commission something to respond to. So there will definitely be some structure to that conversation. I apologize that I didn't make that clear earlier, but we will have some document. We don't have it right now, but we will have it by June 22nd.
Commissioner Arner, followed by Vice Chair Warner.
There's another group that I think would be helpful for us to understand what their role is. And this came out of a discussion that Jan and I had yesterday, and that's the role of elected officials. And where do they come into this process, right? Because it's not clear in my head anyway yet as to whether or not there is a standard role for them, or if it's different depending on where the jurisdictions are and who makes that decision and all of that. The judiciary, we all know, because there's so much litigation in this area. But I'm just wondering if it would be helpful to also understand what the role of the local elected official is. The legislature is writing the statute. I understand that. But, cities and counties and other jurisdictions are making decisions. And what's the role of those elected officials that are at those different levels of government?
Thank you. Commissioner Warner, and I see we've been joined by Commissioner Byer, but Sean, please.
Well, first and foremost, I am just so pleasantly surprised to see David Byer looking so distinguished.
Thanks, John.
It's good to see.
I can put the suit coat on if you want.
I'm maybe I'm looking at this way too simplistically, but the reason we embarked on this study, I believe, is to address abuses and delays that CEQA has caused in development in California. And with the housing crisis, which has been noted throughout this, it seems to me there are some areas there we can focus on and see if they can be addressed. And I get that this is like boiling the ocean, but if we could find those specific items that really are not easy to tackle, but are appropriate to tackle from an abuse perspective and delay perspective, in order to help the state government look at responsible development in California. Development's not going to stop here. We've got a lot to do, especially from a housing perspective. So I would just say if there's a way to address those specific issues maybe first without going this too broad. I don't know if that's possible or not, but that's just my simplistic view of it.
Yeah, thanks, Sean. Before I go to Commissioner Byer, that kind of sounds like, if memory serves me correctly, some of the witnesses on our first hearing who said there should be areas of priority, and that perhaps we ought to be looking at areas of priority with respect to CEQA and its implementation. But let me go to Commissioner Byer.
Well, thank you. I'm sorry I missed the earlier part of the session. I had to attend a funeral for a friend, and here in DC. Let me take a slightly different view from Sean, and it's mostly to provoke a conversation. I looked at Tristan's memo, and I'm almost in mourning thinking about his departure because he's been such a stalwart on the staff. I've already reached out to the Bipartisan Policy Center, my friends Bill Frist and Tom Daschle, and told him to look forward to Tristan's work. And they're looking forward to working with him. So, but going back to Tristan's memo, it seems pretty clear that everything that could be tried has been tried, and that it is not some magical political formula where you put together this interest group with that interest group, because politicians far more skilled than me, but maybe not as skilled as some of the others on the commission, people like Darrell Steinberg, tried and did not succeed in broad comprehensive reform. However, having said that, I think if we don't offer provocative ideas or new ideas, we're not adding to the debate. Because if at the end of our report, everything that could have been known before we started having the hearings was known, we will have not added anything to the storehouse of knowledge. And I think there are a couple of things that stand out for me. One on the modest but important front, which is in comparison to other states and to the federal environmental statute, I believe that people who bring litigation have to have some kind of legal term standing to sue or some interest that they're articulating that has legitimacy and it's not a hypothetical or theoretical interest. To me, that's a reform worth pursuing, even though it does have a history of not being accepted. I think there are ways of writing that, and that's a detail. On the flip side, I do not support the idea of a specialized court because my life experience is, having worked on creating one for the patent system, that those courts tend to be captured by the interest groups they're litigating for. And in this case, I think the bigger risk is to take CEQA in a more obscure way because the judges will want to make new law. And I don't think that's what we need. I think there's been too much, frankly, judicial activism in finding new areas for CEQA to expand into to the detriment of the other social policy goals of the state. So I'm interested in the views of others, but I got to say, I don't think it's just limited to housing. And if we were to just limit our recommendations to housing, I think we'd be doing a disservice to the state with respect to other goals. As Tristan's memo points out, there's a flavor of the month-year era that previous things, whether it's climate change or housing or permitting energy facilities, there's always some reason why CEQA is a problem. And we'd be better off, in my view, if we tried to comprehensively deal with CEQA reform and not do it on a specific subject matter basis.
Very good. Any other commissioners? Maybe, Ethan, you can give me some sort of hint as to what are we looking at on public comment?
Well, we must take at least half an hour of public comment as specified on the agenda.
Okay. I see there's 97 participants.
Yes, and I will check momentarily on how many have indicated a desire to make public comment, but often people add themselves to the list after we start, so it's a little
right.
So, if I may, Mr. Chairman, if it meets with the commission's approval, just to try to summarize what we have heard in terms of the types of witnesses the commission might wish us to invite for June 22nd, and then we would go back at the staff and subcommittee level and work on that. The biggest, as I hear this conversation, the biggest sort of bucket of witnesses would be around the role of the judiciary. That might, in terms of specific people, that might be former judges, it might be someone from the Judicial Council, it might be academic experts, whatever the case may be. But I think the biggest thing that I have heard is that the commission is interested in hearing from people with regard to the role of the judiciary in all of this on the 22nd. I could circle back with Commissioner Cannella with regard to providing some more information about the wildfire report, which was, of course, done before he joined the commission. I think there is relevant information in that report. And I also might, Commissioner Cannella, I'll provide you with some information from testimony from local government officials at the last meeting that I think you missed, some of which dealt with public works projects. So you and we could have a conversation about that. But I think we may have received some information on public works projects, and I think that the wildfire information may be contained in the previous report. So I think that the biggest single bucket of witnesses, and again, we'll work through this at staff and subcommittee level, perhaps there are others, but I think the biggest single bucket is the role of the judiciary. That is what I would take as our marching orders for the 22nd, Mr. Chairman, at this point.
Sounds like it to me. I don't see any virulent opposition. Okay, all right. Good.
So if
Good.
that's the case, that is what we will focus the 22nd on. And I apologize, I cannot actually, I'm holding this meeting on my phone due to some technical problems, so I can't see the other commissioners at the moment. But in any event, I'm assuming you would tell me if someone was waving their arms in protest. So we will the biggest single focus, there may be perhaps other witnesses, but the biggest single focus will be the role of the judiciary bucket, for lack of a better word.
Yeah, I think that's acceptable.
Excellent. Then, Mr. Chairman, I defer to you whether you want to have any further conversation or if you want to now go to public comment. It's already 1:18.
Yeah, let's do public comment.
Okay, very good. And then again, I just will repeat for Commissioner Hernandez and others, we will bring some structure to the 22nd conversation. Okay, so with that, Mr. Chairman, we can move into the public comment phase of the meeting. I'll ask the staff to put up the instructions. If you're a member of the public who has joined the meeting via Zoom and you wish to make public comment, please use the raised hand function in Zoom. If you have phoned into the meeting, email us at littlehoover@lhc.ca.gov. That address is on the screen. Email us immediately and give us the phone number from which you're calling so we know who to unmute. But if you've Zoomed in, just use the raised hand function. In keeping with the Commission's traditional process, public comment is limited to 3 minutes per speaker, and the commissioners will be able to hear you but not see you when you make public comment. We have a set limit in the agenda of 30 minutes total public comment. If you are not called upon today, as you have heard, we will be taking public comment on June 22nd. That meeting will be live streamed. So even though it will be a physical meeting in Sacramento, you'll be able to make public comment at that meeting remotely, or you can also email us whatever comment you wish to send us at littlehoover.lhc@lhc.ca.gov. With that, I will ask Shara if we have people who have indicated a desire to make public comments.
Yes, we do. Currently, we have about 20 people. So the first person we'll be taking comment from is Lynn Plumbeck. You now have the ability to unmute yourself.
Hi, my name's Lynn Plumbeck. I'm down in Southern California, Northern Los Angeles County, the Santa Clarita area. It's a very high growth area. And so there's been a lot of CEQA issues down here. And I did send a communication to you all via email about some of the great successes that CEQA has brought to public, like monitoring in the community of the landfill, which would not have occurred without a CEQA process. Solar roofs that are now state law, but were not at the time that Newhall Ranch was approved, creating massive amounts of greenhouse gas, and really looking at because of CEQA, the project was modified to substantially reduce the greenhouse gas generation. And I understand that you feel that CEQA delays. However, when you have a large project, it doesn't delay small projects because they're often approved through a mitigated negative deck or a negative declaration, which doesn't involve writing an EIR, it doesn't involve responding to public comments. And it's for small projects that are less impactful. But when you have a really large project, it's really important that there is an ability for the public to insert itself in the process. The public often knows things that just aren't in the EIR. The EIRs are paid for by the developers, and although sometimes in our area, they don't choose their own consultants, they have to choose from a list. The way it works is that if you say anything bad in an EIR, you will never get work again. So it's really important to have the ability for the public to comment. And if you don't have this ability and you create a really large project, and then you find out, oh my gosh, the traffic can't be accommodated. We should have required freeway expansion, which they ended up having to do for Newhall Ranch. Then you have something down the line that is far more detrimental to the public and may cause far more delays in public expense than not having addressed it right at the beginning. And I think it might be helpful to the commission to evaluate how many projects CEQA actually really stops or slows down versus how many are not affected by CEQA at all, other than receiving public comments and review through that process. So, I mean, I think you all understand, and if, you know, I heard that there was practitioners of CEQA on the commission, that a negative declaration is 20 days. And it just allows the public to be aware that something's happened in case they know of an issue that may be a concern to the decision makers. So I think I hope that I didn't attend the earlier meetings because I didn't know this was happening, but I do hope that you evaluate really how many projects are affected by CEQA and how many are approved without any issues at all. So thank you for your time.
Thank you. This is Pedro Nava, and I would tell the last speaker that the prior meeting, should she be interested, or on video, that she can access that through our website.
Thank you. Our next speaker is going to be Bonnie Robinson. You now have the ability to unmute yourself.
Thank you. My name is Bonnie Robinson, and I'm active in my community working with environmental and affordable housing issues in the city of Orange. As stated by others, CEQA is currently a strong tool to inform city decision makers whether to proceed on a project. It helps to ensure there will be no harm to the environment or human health due to proposed project's impact. And it is also one of the few tools available that we as residents of our community have to help protect our living environment. Provides for smart, sustainable land use planning and is a check against overdevelopment in a community. And because the people who live in the community and know the area best have an opportunity to weigh in on the impacts of a proposed development, it is more likely that problematic issues will be addressed and mitigated, or the project will be denied due to its inappropriate nature for the area. In our community, we are concerned about current and possibly additional exemptions to CEQA that are at odds with two other state goals. The first of protecting 30% of our open space by 2030 to protect the environment, limit global warming, ensure biodiversity, and provide a healthy environment for humans, flora, and fauna in which to live. And that of equity and justice, so that housing is not built in areas at risk for flooding, in fire zones, and next to other hazards, solely to have more housing for affordability purposes. We have developers in our area that are attempting to take advantage of exemptions and loopholes in the current laws and are proposing housing developments in our creek corridor areas that are zoned or designated open space and are at risk for flooding, and in one case where hazardous demolition waste has been dumped. These developers purchase land not intended for their intended purpose of development and are trying to take advantage of exemptions in the name of producing affordable housing, although only a very small percentage of that housing would actually be affordable. And even though there are a sufficient number of properties in our community that are zoned mixed use and are identified in our housing element as possible sites for affordable as well as moderate market rate housing. Therefore, we don't believe that additional exemptions should be made to CEQA and do believe loopholes need to be addressed. In addition, as stated by a few of the speakers during this series of hearings and those by presenters in a recent 30 by 30 presentation, the full environmental review and comment period of CEQA should take place early in the proposal process so that there are no surprises either to residents, city decision makers, or the developers. Negative proposal impacts can be addressed early in the process before additional funds are expended and prevent an inordinate amount of time taken to address issues that come up late in the process. And in response to Mr. Curtin's testimony today, all labor forces should be paid living wages, and especially if the developer is going to benefit from public enhancements. So whether it's done by statute or in another way, in the long term, it should lessen the need for public benefits for many of these families of construction workers and lower the need for so many very low and low affordable houses. Thank you so much for your time. I appreciate having the opportunity to speak today.
Thank you. Our next speaker is going to be Erica Valentine. You now have the ability to unmute yourself.
Good afternoon. Thank you for this time to speak. My name is Erica Valentine. I'm the political director for UA Local 393. We represent the plumbers, pipe fitters, steam fitters, and HVACR service technicians in Santa Clara and San Benito County. We have over 3,100 workers. We are in fact skilled and trained in commercial, residential, as well as service. We also are part of a nationwide network amongst the United Associations. We have several hundreds of thousands of workers that are ready to perform and build residential housing. We ask that you please uphold the CEQA process. We stand with the building trades and hope that you understand that this is important not only for us at our work job site, it is also for our community to ensure that we have a safe place for us to work and live in. This benefit is for those that do not have a voice here today. We ask that you please vote to keep the CEQA process alive for the health and safety of our nation. I would also like to invite any and all of you to come and have a tour with any one of our many subcontractors and meet our members that are skilled and trained and ready to work and eager to work on these projects. Thank you.
Thank you. Our next speaker is David Beanie. You now have the ability to unmute yourself.
Yes, thank you. Good afternoon. I would like to offer some context for Vice Chair Varner's inquiry regarding the importance of union participation in the CEQA process. There are projects where unions have participated in the CEQA process that have had very positive results. And I'm just going to give you one example from Alameda County. Just last year, an East Bay coalition of unions challenged a West Oakland housing project that was proposed on a contaminated former industrial site that's located next to a major freeway. The city's CEQA analysis had incorrectly said that the contamination had been cleaned up to residential standards when it clearly hadn't been. They also said that the future residents would not be exposed to hazardous air pollution from the freeway without analyzing the cancer risk. The Union Coalition appealed the project to the City Council with evidence that demonstrated that the contamination had not been cleaned up to those residential levels and that the site was consequently not ready for residential development. These unions also demonstrated that the city had not analyzed, at least not adequately, the health risk to future residents as is required by CEQA. The City Council then unanimously upheld the appeal. The upshot is that the city is preparing a revised CEQA analysis that addresses the soil and groundwater contamination. They're adding new mitigation measures, adding soil cleanup plan, all to ensure that this project site would be clean to residential standards before construction workers, as well as future residents, are at the site. The City Council also added conditions to which the project applicant agreed to provide health protective air filters in the project's residential units, which are located near the freeway. This just is one example, and I would like to thank the unions for their positive impact. This is a great help to communities, and it wouldn't be possible without this CEQA process. Thank you for your time.
Thank you. Our next speaker will be Jesse N. Marquez. You now have the ability to unmute yourself.
Hello, my name is Jesse Marquez. I'm a 71-year-old lifetime resident of Los Angeles living in the Wilmington community. I am the founder and executive director of the Coalition for a Safe Environment, an environmental justice organization established in April 2001. We have participated in the CEQA process for over 22 years. We have submitted over 50 public comments in person and written documents. We averaged 10 to 25 other community sign-on organizations that supported us. We have commented on City of LA projects, Long Beach projects, Port of LA projects, Port of Long Beach, LA County, Caltrans, South Coast AQMD. We consider ourselves experts. Every CEQA I have reviewed had numerous CEQA non-compliance issues. You're talking about the long time, the extended time it takes to get a CEQA EIR approved for a project. Well, I can tell you the explanation and the reasons for it, but I want to answer one of the comments that one of you commissioners made that was brought up. You better check your facts. 99% of all filed CEQA lawsuits filed by plaintiffs have legal standing. This is just industrial rhetoric to give the impression to people who are not involved, which includes commissioners and the rest of the world, that they're all frivolous. They're all trivial. They are not. I'm asking you to do your homework and look at the facts and figures. The number one reason CEQA project proposals are challenged in the draft EIR and final EIR public comment process is because the EIR failed to comply with all CEQA requirements. The known reason CEQA lawsuits are filed against the government agency and the project is because the EIR failed to comply with all the CEQA requirements. You brought up about the judges getting involved. We'll tell you about the judges getting involved. Judges support government agencies over the public and take a blind eye towards public comments challenging deficiencies in the final EIR, which forces the public to file an appeal. And so that you know, the public normally wins 90% on the appeals. Okay, so we're not talking frivolous anythings. Agencies use overriding considerations as an excuse not to do any more. That's it. They just decide, oh, we're fed up. It's taking too long. They want to get it over with. Problems, all direct and indirect emission sources are always not identified. All direct and indirect emission source impacts are all not assessed. All direct and indirect emission source impacts are all not mitigated. All direct and indirect impacts are always not even identified. All direct and impact impacts are always not even assessed. And as a result, they are not mitigated.
Mr. Marquez, your 3 minutes expired. If you can wrap up quickly, please, sir.
Okay, I'll just say that as commissioners and as a commission, you have a fiduciary responsibility to conduct your due diligence to verify public claims. That's what we're asking. And that there was no advertising about this meeting other than your limited list. If we're talking about the CEQA process, it should be advertised in all newspapers, and you should create an environmental justice organization list so that all these organizations who do get involved are involved and can support what you're doing. But we want the truth to come out and the facts to come out. Thank you.
Thank you, Mr. Marquez. Shara, we can go on to the next witness, please.
Thank you. Marianne King, you now have, oh, I'm sorry, Marianne went away. So we have Jeremy Smith. You now have the ability to unmute yourself.
Thank you. Can you hear me?
Yes, we can.
Great. Thank you. Jeremy Smith here on behalf of the State Building and Construction Trades Council of California. We represent over 400,000 construction trade union members in the state, along with around 66,000 apprentices in the state approved apprenticeship program. First of all, we are concerned that there are likely a number of members of the public waiting to speak today who might not get to given the 30-minute limitation. We would urge the commission to hold another hearing, which you're going to give the public enough chance to be heard, and hopefully that hearing will be in person. We appreciate the committee's time today to discuss CEQA, one of the state's most important environmental and public health protection laws. And to expand on Commissioner Byer's line of thought, a law that has been amended over 20 times over the last 5 to 10 years just for residential housing construction, and already includes over 40 streamlining, exempt, and other exemptions, yet construction is still not happening. CEQA is a critical law establishing a process for protecting California's communities and for ensuring that development proceeds safely and sustainably. Provides all members of the public, including union members, the right to participate in approval of development projects to ensure that environmental and public health impacts are mitigated before projects are approved. Our union members live and work in the communities where projects are built. They rely on the CEQA process to enforce environmental and public health laws that ensure a safe working and living environment for themselves and their families. CEQA is especially important to union members who construct projects because they are the first in line to be exposed to health and safety impacts that exist on site. Things like soil contamination, air pollution from construction equipment, and excess noise. It is also important for their families and their communities who experience the long-term impacts of developments where they live. Unions and their members present decision makers with evidence about those impacts and ask them to mitigate the impacts through CEQA review. Union participation in the CEQA process benefits all Californians. For example, union participation in the CEQA process for industrial projects over the last 40 years has led to the reduction of thousands of pounds of air pollution from industrial facilities that would not have occurred but for unions intervening in these projects. Union participation in commercial and residential projects has led to investigation and cleanup of soil contamination on former industrial sites that are converted to residential use, reductions in construction air pollution, reduced health impacts on local residents, reduced impacts on water quality, and increased energy efficiency and protection of the natural environment, to name a few. Those are just a few examples of how unions rely on the public review process under CEQA to improve the health of their communities, whether or not they work on constructing the projects themselves. We urge the commission to recommend that the state uphold CEQA's environmental and public health protections for all citizens and to look deeper into the reasons why more residential housing construction is not happening, given the fact that the statute has been amended so many times already over the last decade. Thank you.
Thank you. Our next speaker will be Christina Marquez. You now have the ability to unmute yourself.
Thank you. Good afternoon, commissioners. My name is Christina Marquez. I'm the environmental organizer for International Brotherhood of Electrical Workers, Local 569, representing over 3,600 power professionals and union electricians in San Diego and Imperial counties. I'm also a journeyman electrician and have personally benefited by being in an apprenticeship and going through it, earning while I learn, getting paid the same as the guys. And now as a journeyman, I can help to advance women in the industry, as well as the men and people that are in communities of concern. I also live and work in San Diego. As the environmental organizer, CEQA is important to me and my family to ensure I can participate in the process to encourage and provide my input on the impact projects may have on my community. I have participated in the CEQA process, leading the fight for dramatic reductions in emissions of air pollutants and construction activities and exposure to toxic chemicals. I have participated in the CEQA process to explain the significance of exhaust emissions from construction equipment and to advocate that such equipment be required to use oxidizing soot filters to reduce emissions. Major improvements have been made in the state of California as a result of our participation. I rely on the public process under CEQA to inform my elected officials about these impacts. It is important that we have a voice to ensure projects mitigate their impacts, especially for those communities that don't have a voice and don't know all the air pollutant dangers around. Thank you for your consideration of my comments. I really appreciate the time, and I yield my time.
Thank you. Our next speaker will be Marianne King. Marianne, you now have the ability to unmute yourself.
Thank you. Can you hear me?
Yes, we can.
Thank you so much. I put my hand down by accident, so I appreciate you letting me in. I really like what Commissioner Varner is focusing on, which are the abuses and delays of CEQA. And I think, what we heard today is that, some people want a seat at the table. It doesn't really have anything to do with CEQA. And a question was raised, what is the role of elected officials? Well, I'm not an expert. I'm not an elected official. I'm a previous city planner, by the way, with the city of Los Angeles. But I would say if I were an elected official and I had groups that kept appealing cases in my district, I would bring them into the office, sit them down and say, how can we work together? Because this is ridiculous. I mean, stop just sabotaging projects. And I believe so that's what I would do. And the other thing is there's a lot of people that are laymen that really don't understand CEQA, but they don't understand planning. And when a project is approved, they're like, oh, the traffic, all this stuff that they don't understand. There's thresholds, there's all this technical aspects to it. Maybe, educating those community members or being more helpful so they kind of understand that there are specific triggers, because that would reduce, I would hope, appeals. Another thing is qualitative. Some of these appeals and the responses they get are pretty straightforward. You didn't provide enough substantial evidence, so therefore, I'm not going to entertain the appeal issue, or it's a very vague response. And I think qualitative goes a long way, especially also with EIRs. And I just want to point out really quickly, our housing element that was approved by the state has an EIR, which I don't believe is addressing. It's a policy document. It's not addressing implementation. as far as cumulative impacts. So to suggest that we just go with a program EIR and say there's no environmental impact is wholly wrong, just wrong. And so I just wanted to thank you so much. I've been enjoying all of these hearings, and I just wanted to just say a few things. So thank you.
Thank you. Our next speaker will be Mundo Escarcega, UA Local 393. You now have the ability to unmute yourself.
Great, thank you. Yeah, my name is Mundo Escarcega. I'm a member of UA Local 393. We are over 3,100 workers, plumbers, steam fitters, HVACR service technicians in Santa Clara and San Benito counties. We perform commercial, residential, and service work, and we do in fact have skilled and trained workers ready and eager to build residential work. I live and work in San Jose. I have firsthand experience about the effects of air pollution, traffic noise, and lack of public services. I rely on public process under CEQA to inform my elected officials about these impacts. And it's important that we have a voice in order to ensure projects mitigate their impacts. We stand with the building trades, and we stand with CEQA. And thank you for the consideration of my comments.
Thank you. Our next speaker will be Terry Brady. You now have the ability to unmute yourself. Terry Brady, please unmute yourself.
Can you hear me?
Yes, we can.
Okay, great. Hi. I just want to say that CEQA matters because it's the way communities are notified of impacts to their community on air quality, traffic, and loss of biodiversity. Participation in the CEQA process, making comments, is a rewarding civic activity. The EIRs I have commented on include the Disney EIR in Topanga Canyon. This proposed project led to an EIR because many species and much habitat would have been impacted. It's 4 miles into the Santa Monica Mountains. A development was proposed by one of the heirs of the Disney fortune. The community raised concerns about the impact to wildlife and the community values if mansions were built in this primarily wild area. This development was ultimately stopped because, first of all, the owner was a willing seller. And second, the County of Los Angeles wished to buy the property. It is now a county park. I believe it's called Edelman Park. All the native flora and fauna, which were at risk, are still there for the enjoyment of all. Another project I commented on was the red-tailed golf course and the Tahunga Wash. This development had similar environmental impacts and similar community concerns. However, the developer was not a willing seller, and though the proposal was in a floodplain, due to developer threat of lawsuit, the golf course was ultimately allowed by the City of Los Angeles in the Tahunga Wash. Other developments I have commented on have been adjacent to wild areas or pockets of wild habitat within the City of LA. While these are not expanses of wild land, they are still important to wildlife and people who need wild places. These include Deer Lake Highlands, a development at the top of Topanga on the north end near the 118. This was critical habitat for deer. It seems that most developments name themselves for what was once there. This did include housing, but it was also important habitat, and it will have global warming impact since it was not close to public transit, and it was on the very edge of the urban area and into the wildlands. Another development that was similarly adjacent to wild areas was a project in Calabasas that was developed. It did include housing, but it was also caused habitat loss, and that was actually approved. The city, anyway, that was a complicated process that might be what you're concerned about as far as lawsuits, but it was complicated because it was important habitat, and while it might have provided housing, it had a serious impact on community aesthetics, and habitat loss. And I believe it's very important that that the community be able to be included in this process, and that's what CEQA allows. These concerns that are raised by CEQA process are important. They rarely stop a development. They often require the development to be adjusted to avoid or mitigate some of the environmental harm.
Ma'am, your 3 minutes has expired. If you can wrap up quickly, please.
Okay. I have 2 more paragraphs, or I could just make a couple of lines.
Just please make it a couple of lines so that we can hear from other members of the public.
CEQA is a benefit to the community as it alerts us to environmental impacts that are irreversible. I hope that CEQA will continue to be a tool of community involvement in the future. It benefits wildlife and communities.
Thank you, ma'am.
Thank you. Our next speaker will be Vince Sugru. You now have the ability to unmute yourself.
Good afternoon, commissioners. My name is Vince Sugru, and on behalf of Sheet Metal Workers Local Union number 104, I want to draw your attention to the immense significance of the California Environmental Quality Act as a crucial mechanism for safeguarding construction workers on job sites from hazardous materials, particulates, and other potential health risks. CEQA stands as a powerful shield, ensuring the protection and well-being of those who dedicate themselves to the construction industry. With that, I want to emphasize that I do not agree with the Carpenters' statements about CEQA and that they do not represent the majority of unions in California. First and foremost, CEQA requires comprehensive environmental assessments for construction projects. These assessments thoroughly examine potential hazards, such as the presence of toxic substances, dangerous particulates, or harmful emissions. By identifying these risks up front, CEQA enables the implementation of appropriate measures to mitigate and manage them effectively. Construction workers deserve to work in environments that prioritize their safety, and CEQA plays an indispensable role in achieving precisely that. CEQA's emphasis on public input encourages the adoption of best practices and cutting-edge technologies. As concerns about hazardous materials and particulates evolve, so too does the need for innovative solutions. By engaging the collective expertise of construction workers alongside environmental specialists, CEQA fosters the development and implementation of advanced safety measures. This collaborative approach ensures that workers remain protected from evolving risks throughout their careers. Just to look at the sheet metal workers industry specifically, many of our members who performed work prior to the passage of CEQA in 1970 are seeing higher rates of mesothelioma and leukemia than the average population due to the exposure of hazardous materials. Ultimately, CEQA is not a regulatory burden. It is a lifeline for construction workers. It empowers us to demand safer working conditions and ensures that our health and well-being are never compromised. By embracing CEQA as a mechanism to protect construction workers from hazardous materials, particulates, and other risks, we can forge a construction industry that not only thrives, but also prioritizes the invaluable individuals who build our communities. Thank you for your time.
Thank you. Our next speaker will be Ann Cantrell. You now have the ability to unmute yourself.
Thank you. Good afternoon, commissioners. Ann Cantrell, co-chair of the Sierra Club Los Cerritos Wetlands Task Force and board member of the River Park Coalition in Long Beach. I have often said that 30 years ago, I had no idea of what an EIR was. Now I go to bed with one almost every night. In 1995, the city of Long Beach had approved leasing 45 acres of El Dorado Regional Park to a private company to build commercial sports park. A group of concerned citizens formed Save the Park, and with the help of a pro bono environmental attorney, filed and won a CEQA lawsuit. The city found another site which proved to be equally unsuitable and is now Willow Springs Park. So CEQA saved parkland in 2 areas of our park poor city. In 2022, the River Park Coalition challenged a council-approved negative declaration which allowed a warehouse RV parking lot on oil property next to the LA River. The judge has ruled the negative declaration inadequate and is requiring an EIR for the project. More and more, we are seeing our city use negative declarations and categorical exemptions instead of an EIR for projects. The public is forced to sue in order to ensure CEQA compliance. If you have any chance to change CEQA, I hope it will be to strengthen, not weaken it. Categorical exemptions and mitigations weaken the protection of the environment. Mitigation does not eliminate environmental impacts, it just moves it elsewhere. I hope when you decide what your report is going to say, that it will be to strengthen CEQA. Thank you.
Thank you, ma'am and Mr. Chairman. With that, we have reached our half-hour limit on public comment, and so I think we can close the public comment session of the agenda. Before we adjourn, Mr. Chairman, and I turn it back to you, I would just note, as the commission knows, we are working to schedule a meeting for full commission consideration of the organics report. You'll be hearing from me very, very soon, probably either today or tomorrow. In fact, it will be either today or tomorrow. With regard to the date, I appreciate that everyone got back to me quickly in terms of their availability. So we will be trying to schedule a meeting soon to consider the organics report. And then, as we all know and have been discussing, we'll have a meeting in Sacramento on June 22nd for the final CEQA hearing. With that, Mr. Chairman, I'll turn it back to you.
Yep, thank you very much. I want to express my appreciation to the commissioners for their discussion and conversation and what we've had so far on CEQA and your thoughts, and wish everyone well, and we'll see you soon. Stay healthy.